Good morning, folks. My name is Shantae Jordan. I'm the FUQA Chair of Speech and Debate at Pace Academy in Atlanta. I'm also the chair of the NDCA, and I'd like to personally welcome you to our third annual education conference. The previous two were in Dallas, and we decided to come to Chicago in hopes of getting more of the local coaches and people in the surrounding areas to hopefully attend the conference, give us their feedback and thoughts about what we can do going forward for education conferences. And so welcome, we're glad to see you this morning. So Adam and I are gonna start the conference, and I'll let him introduce himself and then we'll get started.
Hello everybody, welcome from me as well. My name is Adam Torson. I am the debate program head at the Marlboro School in California.
Where in California?
What's that?
Where
In Los Angeles.
And you're also,
Hmm?
tell them what you want to do.
Oh yes, I'm also on the board of the National Debate Coaches Association. A proud member indeed. And I have a Juris Doctorate from Hamline University School of Law, so we'll be talking a little bit about some of the legal principles in our presentations.
All right, awesome. So we're gonna get started. So the link to slides, we'll post all of this at the end. And I think Christina emailed to the listserv how you could get access to this as well. So in the age of the Me Too movement, debate coaches and tournament directors are increasingly having to deal with issues of sexual harassment being told by their students, past and present. And so the goal of this session is to create dialogue amongst us in the room in an effort to eventually create a tournament best practice centered around sexual harassment that will primarily be the guide for the NDCA National Tournament Championship. However, for programs that would like to follow that, it would be in place for you to follow that and or at least publish it so that attendees at your tournament, etc., would know policies that you have in place to sort of address sexual harassment and sexual misconduct, rather. All right, so as you can see, the Me Too phrase was originally coined by activist Tarana Burke in 2007, but obviously it did not get the sort of publicity as it did until Alyssa Milano tweeted it following the sort of Harvey Weinstein situations and accusations that popped up. So there were a number of entertainers, a number of business people, a number of people in print and broadcast media, et cetera, that were accused during this time, and there have obviously been accusations since in government and academia as well. And so we thought, along with sort of consulting some coaches, that this was a very timely topic, and that it probably is one, if not the most pressing issue that confronts high school debate currently in speech and debate. And so we thought very timely, and we'd love, obviously, to get your feedback as we sort of progress. If at any point you have questions, please raise your hand, let us know, we'll answer as we go along. Okay, so for those of you that don't know some of the history that centers around policies that are currently in place, there were two particular court cases. So in Gebser versus Lago Vista Independent School District, which is in Texas, that particular sexual harassment case dealt with a school employee committing sexual assault and sexual harassment versus another employee. And then Davis versus Monroe County, which is a county in Georgia. This dealt with peer harassment, so student-on-student harassment. The first case was in 1998. The second case was in 1999. And both of these individual cases eventually went to the Supreme Court. As a result, the Supreme Court decided that, as you can see on the screen, that school districts would be held accountable, strictly liable for sexual harassment when an employee is in a position for remedial action, especially if they have knowledge of the situation, and that those employees or schools have exhibited deliberate indifference to correcting the situation. So both of those things have to be in place for school districts. And we're gonna talk about it in a second because we work in independent schools, and I know a number of you work in independent schools, so we'll talk about possibly the differences between public schools and independent schools. But just know that the Supreme Court has put in place to indicate, hey, here's what should be in place to prove that there has been some level of sexual harassment, either by an employee on another employee, or employee on student, or student on student harassment. Okay, so many of us work in independent school environments, and many of us work in public school environments. So I think the first thing that's important to kind of discuss is whether or not the Supreme Court decision is even applicable to independent schools. And so, to my knowledge, unless those lawsuits get to the level of litigation at the Supreme Court level, a lot of this doesn't technically apply to independent schools because we all have our guidelines, honor code, discipline that we're supposed to follow as it relates to sexual harassment and sexual misconduct. In terms of public schools, the difference, obviously, school boards, school elected officials that represent districts, has some not liability, but they are the place where eventually all claims, accusations, etc. go to. The difference though with independent schools is that there's a school board, so you have a headmaster, like principals in each division, headmaster, and then for some schools they have presidents, and for others, above the president and or above the headmaster is the board, the elected board or board put in place by the headmaster. Ideally, a lot of the things that we've shared earlier about the Supreme Court decisions, they are not necessarily thought about at all in independent school districts. In fact, a lot of sexual harassment or sexual misconduct claims get no further than the headmaster in independent schools. So the headmaster, principal, teachers, parents either make some agreement or students end up leaving based on certain situations that occur in independent schools. Public schools, however, because there are unions, because there are other things in place, that allows parents, and now these Supreme Court decisions allow parents to further, sue or do other things to bring to light sexual harassment claims or sexual harassment misconduct that's occurring in the school system, whether it be student versus students or whether it be adults and students. So the next thing that complicates what we do as coaches and teachers is the fact that we travel so much. We go to so many different campuses. If you go to a college campus, clearly there's sexual harassment, anti-harassment policies that they have in place for their university or their college or university is in place. So if those of you that attend the TOC, Dave Arnett's been pretty good about publishing, here are our policies, and those are all guided by the University of Kentucky's policies as it relates to sexual harassment. Any college or university that you travel to, same applies. Now, whether that's published or not, ideally that is the case, that whatever they have in place for their employees or their students, it is applicable to you because you are on their campus in a 2 or 3 day span. For high schools, however, there is nothing that's universally established currently for figuring out what's sexual misconduct, what's sexual harassment, how we deal with that. If there's a penalty, can you bar someone from coming to a tournament? Can you, get an employee fired? Can you get et cetera? None of that is technically in place. Although schools, most independent schools I know are like, hey, we just follow our school policies as it relates to sexual harassment and misconduct. Public schools, I would assume, based on what's in place for your district and school, that you follow those policies. But the question is, what do we do as coaches when we go to those schools and there's nothing spelled out? What do we do if a kid assaults or says something inappropriate to another kid? What do we do if a coach or a judge does that? And so that's what we sort of want to dive into now, to talk about what is considered to be sexual misconduct, what's considered to be harassment, the different components. And as we go through, feel free to ask questions. So in general, sexual harassment, as you can see, is defined as any unwanted, unwelcomed, or uninvited behavior of sexual nature that makes anyone feel uncomfortable or humiliated, etc., offended. There are 3 particular sections that we want to sort of break down and sort of show you what we consider as such. Those are physical conduct, which you see on the screen here. So any unwanted sexual advances, any non-consensual sexual intercourse or advances or assault, threatening individuals, etc. All of those are physical in nature because it requires someone touching someone else or doing something to them physically. All right, so verbal conduct, which I think a lot of what we do as teachers and coaches, a lot of what we see and or hear fall into the latter 2 categories. So there's not a whole lot of physical early on, but there are a lot of verbal comments and visual things that students see and or hear. So verbal conduct, you can see any kind of sexual proposition or demand, obscenities, derogatory statements, etc. And then probably the most common, given the age group that we work with, is all the things that they can share via social media, text, pictures, cartoons, etc. That might be sexual in nature or derogatory in nature. So these are some of the things that we deal with on a daily basis. Ironic, as we were sort of working through this, there are a lot of things that I came across and thought about just like through the years. I'm like, well, my goodness, a lot of people would probably not have jobs, or a lot of students would likely not be where they are today if social media existed like way back, because there are so many things now that students can do with phones and their computers that obviously a lot of us didn't do because technology wasn't as prevalent as it is now. So are there any questions about the first section of this? Because we're gonna do a lot of dialogue talking shortly, but just wanted to lay out the 3 areas of physical, visual, and verbal. Yes?
Just a quick question. Are there specific bylaws in place if we're talking about the debate space itself for certain policies by specific leagues? If we're talking about, I'm from California, so like GDSA or something?
So in terms of national organizations,
Yeah.
The NSDA, National Speech and Debate Association, they have a policy that speaks to sexual misconduct, sexual harassment,
Okay.
as it relates to the national tournament.
Okay.
TOC has, the sort of University of Kentucky guidelines that they ask people to abide by when they come to the TOC at the end of April. The NDCA, we don't currently have a policy, which is why we're doing this, so that we can hopefully create one. And I'm not really quite sure that, I would hope that state leagues, state organizations that are, so for example, Georgia's state organization is run by coaches. It is not a part of the high school association. And so we kind of have a policy, but it's not written in stone. It's not as clear as it could be, as opposed to if we were under the Georgia High School Sports Association. That's something, it's in place. So I think if your schools and or districts are guided by the high school association in your state, then yes, there's definitely a policy in place. But if not, no, unless your individual school has something in place.
And I can actually say a little bit about California specifically. So the California High School Speech Association has policies relating to this under discussion as we speak. In fact, I think this weekend, there's meetings that are discussing this among other topics. So it's evolving. I'm not aware of individual leagues in California that have sexual harassment policies or standards, although there may well be. But I know that at the CHASL level, it's under discussion. Perfect. Okay. So we're going to jump into legal considerations. The first thing I want to say is kind of an overarching thought on all of these things. Well, 2 things. First thing is, though I have a Juris Doctorate, I'm not licensed to practice law in any state. I gave up that dream for the glitz and glamour of debate coaching, so please don't construe any of the following as legal advice. You should consult your school's attorneys as you're writing your own policies. That's thing one. Thing two is, for all of these policies, the difficulty is in assessing what constitutes humiliation or intimidation or offense, these types of subjective words that are in all of the definitions of sexual harassment. As a general principle, when any institution, whether it's a school or a court, is interpreting these types of rules, they'll apply both an objective and a subjective test to what constitutes sexual harassment. So in other words, it has to both be the case that the individual who is the victim of sexual harassment experienced this humiliation or unwelcome behavior or regarded it as unwelcome, but that also a reasonable person under the circumstances would also perceive it in that way. Does that make sense? This objective subjective component. Let's talk a little bit about the specific legal requirements. So most of us have heard of Title IX, federal legislation that requires public institutions and especially schools to institute policies that attempt to promote or protect gender equity in schools. So no person in the United States shall on the basis of sex be excluded from participation in the benefits of the benefits of public education. Okay? So what does that mean as it relates to harassment policies? It means that public schools must first of all have a policy. Okay? A number of schools for most of public school history had no standing policy on sexual harassment. Various rulings about Title IX essentially require that to be the case. So that's why any public school now is legally required to have a policy on sexual discrimination that specifically addresses the issue of sexual harassment. Okay? What do those policies have to include? As a legal principle, generally, the school has to do three things when they know or should have known about harassment. Let me break that first part down a little bit. That when does the school know versus when does the school should have known distinction is pretty important. So when the school actually knows, that's where you see most of these lawsuits, like something was reported and a school official didn't do anything about it, okay? So that obviously is a bad scenario, violates the law. But schools also have a duty to not be purposefully ignorant, right? To have policies in place where grievances are easy to file, to duly investigate any like rumors that they hear, or accusations that are made, so that schools can't remain purposefully ignorant. So that's something all along I think we should be thinking, how do these principles that apply to schools in general apply to debate tournaments? And that's one that I think is going to be particularly important as we talk about what our best practices are going to be there. We have an obligation not just to follow up on reports, but also to put ourselves in a position to know what's happening at our tournaments so that we're in a position to protect the kids at those tournaments. Those things, does that distinction make sense to everybody? Okay, so Title IX says schools have to take immediate steps to end the sexual harassment. That means investigate it right away and take remedial action if it's possible, right? Take steps to prevent that action from happening again. So individuals who have a credible allegation against them, for example, can't be in contact with kids while the investigation is going on, things like this, okay? And of course, to remediate its effects. So if students' academic performances are effective, if they need counseling services, etc., schools are obligated by law to provide those as part of their sexual harassment remediation policies. Do those things make sense? So again, in the back of our minds, we're thinking, how should these policies apply to debate tournaments? And we'll do some brainstorming on that topic. The other thing you should know about Title IX, and you're going to see this in several places on this slide, is that it makes it illegal to intimidate, threaten, or coerce a person who has exercised their rights in trying to get Title IX enforced. In other words, you can't retaliate against somebody for making a report under Title IX. Does that make sense? Okay? So that's important in both the school context and the tournament context.
And I like to interject one thing. To my knowledge, there's a 24-hour reporting period. So from the time that a student comes to you, there is 24 hours for you to report that to an administrator in your school. And then your administrator can take it from there. But it is a mandatory 24 hours. Anything after that, you are breaking the law. And so it is important that if a student comes to you and there's an accusation of sexual assault, sexual misconduct, whether it's at a tournament, whether it's in the building, wherever it may be, you have 24 hours to tell someone about that. Otherwise, you are now playing with fire if it blows up to become a larger issue. So that's something else that you should keep in mind as well. 24-hour reporting period.
Perfect. Do you mind advancing the slide? Sure. Thank you. Okay. So, caveat to all of these procedures is that whenever you're punishing a student in a public school, at least, or in a public school, they have due process rights. Okay. The 14th Amendment says that you shouldn't be deprived of life, liberty, or property without the due process of law, and the Supreme Court has interpreted that to mean that you can't be deprived of your access to a public education by procedures that aren't fair to you. So any major punishment, like suspension or expulsion from school, has to be accompanied by a process that is characterized by rigorous fact-finding and fair procedures. Okay? So that means that students and coaches and judges have a right to be informed of the rules ahead of time, okay? So this is why publishing policies is important. And then major disciplinary action has to be accompanied by all of the things that we think of would be fair in a criminal trial. So notice of the charges against you, fair hearing that allows you to do things like discover evidence, defend yourself, have a lawyer present, have an impartial fact finder, right? All of these things seem super onerous, right? But when we're talking about public school discipline, these are things that students have a right to. So we've got to consider, in the context of a tournament, how do we accommodate these types of considerations? Because as you can see, they're rather extensive, okay? These also include, by the way, a right to proportionate punishment. Now, there are exceptions to these due process procedures, or what I would be probably more accurate in saying is that the less severe the punishment, the less rigorous the due process requirements. So things that are minor punishments like detentions, or imagine like in the olden days, like writing on the blackboard after school or whatever, that these things don't require a full, administrative hearing. But there's a kind of sliding scale about the more severe the punishment, the more thorough and rigorous the procedures for effecting that punishment have to be. Does that sort of make sense? So when we're considering what policies we should create for tournaments, we'll have to take into account what do we think the appropriate punitive actions are for people that we find to have committed sexual harassment or sexual misconduct, and what standards of proof and procedures are we going to implement to effect that. Okay, advancing the slide, please. All right. Tort law. Not only are there laws about how schools have to operate from federal and state governments, you can also be sued, as I think you all know. So crime is to criminal law as tort is to civil law. So if you commit a tort, you can be sued for it. If you commit a tort, you're not a criminal, you're a tortfeasor. That's just a fun fact. Okay, so the main thing we're worried about in tort law as it relates to sexual harassment are negligence claims, okay? In order for you to be negligent and held liable under negligence statutes, you have to have violated a duty that you have to another person. So duty, a breach of that duty, you have to have caused the damages to that person, and there have to actually be damages, okay? So what duties do we have is the most important question, all right? As a general principle, in all of life, you have a duty to act as a reasonably prudent person under the circumstances would act. In everything you do, in driving, in walking down the street, and in taking kids to tournaments. Duty to act as a reasonably prudent person under the circumstances. Under the circumstances includes facts that are specific to you. So teachers who have specific training in the supervision and teaching of kids have duties to do what a reasonably prudent teacher under the circumstances would do. Does that make sense? So when we're forming our policies to avoid the claim that we were negligent in protecting our children's well-being, we have to ask, what is it reasonable for teachers or coaches to do at a debate tournament? Courts in various states have suggested that the negligence standards that apply to schools in particular are some of the things I've listed on the slide. They have to retain qualified and competent staff, adequately supervise students, make sure that their instruction is appropriate and adequate, make sure that the environment is safe, that their transportation is safe. Those are the kinds of things that schools have to think about. So again, if we're applying that to tournaments, what do we think the legal requirements are for tournaments to avoid negligence? In particular, it's important to note, in particular for private schools, that though Title IX only legally applies to public schools, a number of states have adopted Title IX as the duty, the standard of care that all schools, public or private, must meet. So it may well be the case that though you teach at an independent school, that Title IX rules still apply to you in the form of these tort laws where you could be sued for not meeting them. Does that make sense to everybody? So a good standard of care is follow Title IX whether you're an independent school or not. Everybody with me?
Yes.
Okay, perfect. Last quick question about tort law is, people will ask about permission slips. If I get a student to sign permission that they're going to a debate tournament, does that protect me from these negligence claims? The short answer is generally no. I've had a number of parents who've been attorneys who've referred to these permission slips as placebos. If a kid gets hurt, you're getting sued. The more important technical legal reason for this is that you can only assume the risks of an activity that are reasonably foreseeable, right? So if I put my kid on the football team, there are certain reasonably foreseeable risks associated with that activity. So when he sprains his ankle or dislocates his shoulder, I'm probably not able to sue the team or the coach or the district, okay? Sexual harassment never falls under the category of reasonably foreseeable harms that you could waive with a permission slip. Does that make sense? So it's not going to protect you from being sued. Perfect. And last but not least important legal consideration is mandatory reporting. Shante referred to this a minute ago. Every state has a mandatory reporting law. If you have reasonable suspicion of, it varies from state to state, but as a general principle, of sexual abuse, assault or exploitation of a minor, of child abuse or neglect, either at home or in school, of willful injury or endangerment of a child, okay? So think coach driving drunk with kids in the car, like that. Or unlawful corporal punishment, haven't seen it in debate, but you know, it's a crazy world. If you have a reasonable suspicion of any of these things, in every state, you have an obligation to report that to the relevant authorities. Everybody with me? Most of you have had this training in your schools, but I just want to reiterate that if you are in a position to supervise or teach children, you are almost certainly in your state a mandatory reporter. So that definitely includes judges, coaches, and other tournament officials, okay? So, probably okay for most coaches, although not all, but how many of our judges know that they're mandatory reporters and understand that requirement? I bet not very many, right? So that's something that we really have to think about, okay? Couple of, as Shante mentioned, you have an obligation to report right away. Some states have a definite time period, like the 24 hours. Other states have a sort of reasonable, based on the circumstances kind of requirement. But suffice to say, you should try not to delay, right? Because if you have reasonable suspicion that a child is in danger, then time is of the essence in making sure that there's an intervention to correct that problem. Your mandatory reporting obligation is individual, which means that telling your superior or telling a tournament official does not satisfy that legal obligation, okay? Unless you know or watch them make the report, okay? So you have an individual obligation to see that the report was carried out, okay? Most states have immunity for reporting, so you can't be sued for, say, defamation for making a report that includes a person's name, okay? The other component that's difficult to square with some of the, like, Title IX and other requirements is that most mandatory reporting statutes have no duty to investigate. In fact, they'll encourage you not to investigate. So I hear a rumor, do I need to pull in students and start asking questions? Mandatory reporting statutes say no, and most of your school's lawyers will advise you not to do that, okay? So there's a disconnect there between some of the Title IX policies and some of the mandatory reporting policies that we're gonna have to think about a little bit as well. Do those things make sense to everybody? Brilliant. Okay, Ed.
Okay, so my question is, judge is judging the debate, judge is 19,
Mhm.
okay? Something happens in the debate that clearly seems to be offensive, harass, you know, I mean, that sort of thing. 19-year-old goes and tells tournament official, is he off the hook, or is she off the hook, or do they have to go? Is that something that needs to be reported to that school, or what do you think about, what do you think about that?
So from the perspective of a legal requirement, he doesn't have an obligation to report it to the school, at least for mandatory reporting purposes. That's probably a good idea, because that school needs to protect the kid. But I would say as a general principle, obviously it depends on what exactly was said.
Right.
The mandatory reporting statutes are not about sexual harassment writ large. They're about narrower and more severe things that you might know about a student. So sexual abuse, assault, or exploitation, child abuse or neglect. I don't want to say that it will never happen, but I think it's rare that something that's spoken in a debate round will rise to the level of something that triggers the mandatory reporting statute. Doesn't mean it'll never happen. And you saw those definitions of sexual harassment would include some of these things. But I would say that as a general principle, it's probably not the case that something said in a debate round is going to trigger a mandatory reporting obligation.
Yeah, I think the one exception to that, the obvious exception, is the case of kids, you know, reading a narrative, claiming a personal experience with abuse as
Yeah.
part of a debate case.
Right, about themselves, you're saying.
Right,
Yeah, yeah.
exactly.
Yes,
That's
yeah, I
when
agree entirely.
that would come up.
And,
Yeah.
and that has happened.
Yeah.
Right, and I guess that's my question. The kids listening to it, they say, this has happened to me, right? That,
Yeah.
you know, that there is, you know,
Yeah.
violence in the debate space or whatever, and that this has happened to me, right? Am I then obligated to say, this student said that this happened to them, you know, what?
Yes,
you
yes.
know?
I mean, I think the question in that case is, do you have a reasonable suspicion? And if the answer to that is yes, then triggers your mandatory reporting obligation. So if the student is representing, this is my story and this thing happened to me, I think that's reasonable suspicion. I think that's more than reasonable suspicion. So yeah, I think it triggers a mandatory reporting obligation.
I mean, and it could be very well that once that's reported and the process plays out, it could just be debate related. It could just be a story that they're telling in debate. Or, as it progresses, it could really be something that happened to that student, right? And at that point, you get all the powers that be involved once you report it. Coach has an obligation then to go to the school and say, this is what happened at the said tournament with said student. We need to get people involved. Yeah, let's see.
Isn't there also maybe a way to short circuit it quickly by asking the kid at the end of the round, have you already dealt with this legally, et cetera? Have you told others? Have you talked to the police? Because they could be talking about something they've already dealt with. In which
Yeah.
case, I think you may be off the hook, you know?
I don't think you're off the hook from a mandatory reporting perspective.
Really? Even if they say, you know,
well, if they
say,
volunteer,
my father abused me and
Well,
he's in prison now.
I think
probably
again,
off the hook.
Right, but I don't think
again-
that's your job to determine whether or not.
Right?
It's up to the school, the family to confirm that that's been dealt with and it's no longer a liability for those in place.
right, because you're suggesting if I investigate, like, then maybe I'll come to new conclusions. I mean, the language in those statutes is reasonable suspicion. So,
But is it a reasonable suspicion that the child is at risk, or a reasonable suspicion that something has ever happened?
Both, it's everything.
yeah, both of those things I would say. Yeah, I wouldn't just ask the kid. I mean, it's a difficult situation because, so the counter scenario I'm imagining is, imagine a kid is in theater, right, and they perform a monologue that includes what would appear to someone who doesn't know the context to be a highly personal, dramatic situation that would trigger this mandatory reporting obligation. But if I know they're practicing a monologue for the play, then my suspicion, I no longer have a reasonable suspicion, right? Like, I can imagine if, this performance piece is read in round 1 and round 3 and round 5, and we figured out in round 1 that it's not that it's just a story for the debate, you know what I mean? Then, like, I think we could imagine subsequent judges who are aware of that, like maybe no longer have a reasonable suspicion that the kid is in danger. But in most states, this mandatory reporting takes the form of you call a hotline and they tell you what's reportable and what's not, and if it's reportable, it gets passed on to the appropriate authorities, and you're more or less out of the equation from that point forward, unless there's some kind of prosecution where where you need to testify or something like that. I would err on the side of reporting rather than not
Yeah,
reporting.
can I modify the hypothetical and say this is a practice debate at a camp?
Right.
Yeah.
Now I think, I mean, in my mind, then at least what Harvard tells me, they say the Title IX office, you have to tell the Title IX coordinator, and they can do some, and then they make the decision whether, and I know that's not available to everybody else, because we have these like bureaucracies that we can appeal to, but I think, I don't know, I don't know how you square the duty to not investigate with the requirement to report, but I kind of feel like you have to report to somebody.
Yeah, I mean, I'll say that one of the reasons they suggest don't report is you can mess up what you are reporting, right? Like you can get information that is inconsistent with what a student later tells the police, and therefore be in a position to impeach that student's testimony to the police. You can unwittingly notify the perpetrator or cause the student to no longer wish to share that story. And so your continued interference in the situation can undermine whatever professional response there is from schools and police and child welfare services and whatever else has to happen. So in these mandatory reporting cases, again, depends on your school, depends on your state, but I would err on the side of not investigating, and I would err on the side of reporting even if you're not sure. Call that hotline and let the people who are professionals deal with it. I recognize, by the way, this is a difficult thing. I once had to do this at a debate tournament, make a mandatory report. The police showed up at the debate tournament and interviewed students. It was not a good situation, but I'll say this as a general overlay to the things we're going to talk about. Some of the statistics on the slide a few times ago, and the insight of the Me Too movement is that what we're doing now is not good enough. So us being afraid of the fallout and the challenges that are going to come with adopting policies that make this right, or at least attempt to address it, we have to just change our attitudes about it a little bit. And I know that it's a thing that, I'm afraid of it, as I think we all are, about what the implications of this are going to be. But I think we have to make a commitment to do what's hard on these things. Eli?
So you mentioned that some actions might result in the police showing up.
Yeah.
All of us don't have the same relationship to the police. What would you suggest happens when Susie reads her narrative and says, I've been, assaulted, vaguely references, I've been harmed, I've been assaulted in some way. I report, and then the police show up, and then a black dude in the back room, and Susie says, I've been assaulted. What do I do?
Yeah, it's an outstanding point, right? I mean, that we have to increasingly be worried about putting our students in a situation where they have involuntary contact with the police. I guess I don't have especially developed thoughts on this, so I'm interested to hear other people's perspectives. As far as the legal requirement goes, the fear that the police will harm your student doesn't excuse the mandatory reporting obligation. So that might be a situation where you are weighing your thoughts about your individual ethical obligations as it relates to putting your students in contact with the police with your legal obligation to make a report. And that's obviously a bad situation to have to be in.
I'll speak to you as the judge in that situation. I think that your reporting to that kid's coach and whatever administrators are at the tournament separates you in that situation. Like, yes, you may not have the best relationships with police because most black people do not. But the situation at hand is that you involve the coach and our administrator that's tournament, not the tournament director, but obviously that person will be involved as well. But the director for that particular program where the student attends and is there debating, competing under that umbrella, that person should take it from the point where you report to the tournament director and to them. That way you are insulated from any possible legal situation that could come up with law enforcement. Because you have said this is what happened in this particular situation. I've told the tournament, and I've told the coaches, and then now you're done.
Well, I think this speaks to why policy is a good model. What do I do in LD where there's a tournament full of lone wolf children who don't have an adult or an administrator in the state?
Well, I think that's why we're here, right, is to try to create something that tournaments could use as a guide for all divisions. Policy, Lincoln Douglas, Public Forum, World Schools, whatever. And I earlier when you asked what organization, World Schools Debate also, like, internationally has a detailed sexual harassment policy as well. But I think that ultimately, having something in place as it relates to best practices would allow tournaments and different divisions to have something to fall back on and say that we are following NDCA's best practices policy for sexual harassment, sexual misconduct, right? It doesn't matter, and I understand that, yes, LD probably has a lot of young coaches and young judges, but they would also, you know, be subjected to whatever the laws and policies would be per tournament.
I'm sorry, I don't know if this was addressed, I appointed, but, have we thought about having as sort of a group of coaches, I know there's a tournament ombudsman who is the point person at every tournament to handle what, questions about cheating or just.
Yeah, we're gonna get to that. We haven't gotten there yet, but we're definitely gonna get to it, and then we're gonna have some group discussions about that as well.
And I just want to echo a little bit Eli's concerns, because I agree that the difficulty of having adequate supervision, in particular in LD, is a huge challenge. And I think in any of these cases where a report is being made, you're probably also needing to talk to tournament officials and students' coaches to make sure that they're in a position to protect the best interests of their students. I think that tournaments need to strongly consider who they let come to their tournament and ensure that the adults who are there to supervise the kids have the requisite training and understanding of the school's policies, that they can act as any teacher in the school would. And so that's my view. I'm sure that's not the universal view, but for the sake of protecting the students' interests at the tournament, I think that's a very good idea.
Yeah, and the one thing that the NDCA tries to do, we have a policy as it relates to the national tournament, is that if you're not a school employee or signed off on by the principal of that particular school, you cannot attend the national tournament. And so if more tournaments would sort of adopt that particular policy, I think you'd have far less issues with young coaches, young individuals who are just sort of there to be, the supervisor of someone that's 2 years younger. So, Dave.
My question was, so I know that in an ideal world, Adam, you said we could have like every judge that comes on our campus, we could somehow make sure understands like the nuances of mandatory reporting. But like a lot of these people are like college kids who are coming back and judging, and kind of like what Eli was mentioning with LD. So do you think that it would be reasonable for a tournament director to put in their judging obligations, right, or like the expectations that they have for judges, that should any judge witness or hear about sexual harassment or assault experiences, then they have an obligation to follow mandatory reporting standards? And then subsequently, if I like hire out judges, like let's say I bring like some sophomores in college, if they hear a YC that talks about somebody's experience and involves sexual assault, if they come and tell me about it, I mean, I think I can probably do mandatory reporting on that, even though it's like third-hand information, but like how would that sophomore in college go about doing it?
So a couple of things. So the first question was, should it be in tournament guidelines? I think the
Yeah.
answer to that is yes.
Right.
I think that a bigger answer to that is, we don't have the architecture in place right now to make sure that judges have the appropriate training. And I will say, like, we insist that judges be trained, or at least we ought to insist that judges are trained to judge the events that they're judging, which requires some fairly intense training. So I don't think it's overly onerous to suggest that, again, this doesn't exist right now, that maybe there's some online training module, there's something that you do with your judges at the beginning of the year, something like that. We could brainstorm good approaches to addressing this, but I think, yeah, as a starting point, definitely have them in the tournament policies. To the second question, how does the sophomore report? They have to know that mandatory reporting usually involves calling a hotline, so they can dial up that number and make a report. Can you make a report on their behalf? I think it's different from state to state, but as a general principle, the answer is yes. If you have a reasonable, if their report to you creates a reasonable suspicion, and then they know that you're making that report, then that satisfies their reporting requirement and yours.
Okay, excuse me, I'm entering my third year of coaching,
Mhm.
and I keep hearing LD, so what is that?
LD is Lincoln Douglas debate.
Oh, okay.
Good, awesome. Any other questions on the league? Oh, Chris.
I just had, so, I think Dave's question kind of subsumes a little bit what I was saying, but how do we, is there anything that we think, we can kind of draw a line, or ways in which we kind of talk about, ways in which we can kind of talk about how we decide what qualifies as that, in terms of in-round conversations, right? Because if someone's like, you have said this thing that I don't like, or you in the past have done this thing that I don't like how do we sort of begin? Obviously that the architecture is not there, I get it, but how do we begin to sort of have these kind of?
Well, I think that's the goal at the end of this, is to have discussions about what that looks like, how can we put that in place? Is that something that we can put in place?
Okay.
Is that something that, as an organization, we can draft and then people can just follow?
Right.
That's where we're trying to go.
Okay, cause I judge a lot of those debates where somebody goes, and this person is bad because of X, Y, and Z reason, and they're like now saying this in a debate for the first time, and you sit in the back of the room.
Yeah.
Kind of like, how do we begin to be like, well, I think this is a reasonable thing that I should report versus the thing that I shouldn't?
Yeah, absolutely. I mean, I think it's a reason why the definition of sexual harassment is so long, right? Is it requires a lot of detailed figuring out. And of course, in debate, we have to talk about the distinction between unsafe and uncomfortable, because a lot of arguments are going to make students uncomfortable, but will not make them unsafe. And so we have to figure out that line. I agree. Perfect. All right. So should we talk a little bit about some of